Good afternoon, everyone. I'll welcome all of the attendees who are joining us remotely. And on behalf of my colleagues, the members of the INAI, we are pleased to have you with us. We thank you for your participation in this Global Privacy Assembly in 2021. It's an honor for me to be here today to moderate this panel. Joining me, we're going to have amazing speakers. I thank them for accepting our invitation. The topic for this session is consumer rights, e-commerce, and privacy challenges. In light of the COVID-19 pandemic, that digitalization process accelerated, and one of the main actors that has become even more prevalent is e-commerce. This links the protection of personal data as an essential ingredient of cross-border data flows. So there's multiple challenges that we need to tackle when developing digital commerce while strengthening economic competitiveness, promoting cybersecurity cooperation, foster a global, inclusive, responsible commerce and trade, and providing certainty for economic investment. From the standpoint of companies that offer goods and services in digital markets, it is essential for them to consider how to maintain the safety of consumer rights, as well as compliance with their obligations when it comes to personal data protection. Now, from the standpoint of consumers, the interest revolves around the fact that personal information provided be fully protected with proper management of their identity to mitigate the risk of becoming victims of cybercrime attacks, for instance, identity theft. Having said that, I would like to open the session, and I would like to introduce our speakers. First of all, I'm going to introduce each of the panelists. Then they're going to have between 5 and 7 minutes to offer their introductory remarks. Then we will have an opportunity to reflect and chat about some essential questions to highlight aspects related to e-commerce, consumer rights, and privacy challenges. Third, if time allows, we're going to welcome questions from the audience. These questions are going to be collected via the chat on the platform, and at the end of the session, hopefully we will have time. I would like to share some conclusions from this panel. So without further ado, I would like to briefly introduce each of our panelists. I'm very pleased to introduce Alessandro Acquisty. He is a professor of information technology and public policy at the Heinz College at Carnegie Mellon University. His work combines economics, decision-making research, and data mining to uncover the role of privacy in a digital society. His research has led the economic analysis of privacy, the application of economics to behavior, the understanding of value, and decision-making when it comes to consumer privacy. Researching privacy and exposure of personal data on social media. Alessandro has received multiple awards and he has been a speaker at many events on privacy and human behavior. He is the director of the Experimental Economics and Privacy Lab. He is a co director of the Center for Behavior and Decision Making Research at Carnegie Mellon University. He is a doctor. He has a PhD from University of California in Berkeley. He has a master's degree from the School of Economics in London and another one from Dublin University. He has held positions including guest professor at, at universities in Rome, Paris, Freiburg, Harvard University, and Chicago University. Dr. Acquisty, it's a pleasure for us to have you. You have the floor.
Thank you, Commissioner Vergara. It's a great pleasure to participate in your 2021 Global Privacy Assembly, and I'm also grateful to the National Institute for Transparency, Access to Information and Protection of Personal Data for this invitation. The What I would like to use my time with you, a few minutes, to describe some of our work, which may be relevant to this conference, is an attempt to connect about 2 decades of empirical research on privacy and extract some lessons, perhaps, for policymakers. Um, Most of the focus will be on lessons learned from policymaking initiatives in the United States, which traditionally have focused on notice and consent mechanisms, addressing privacy hurdles for consumers by providing privacy policies in privacy settings. I will try to discuss where those approaches have done well and where they have failed, in the hope that some of the lessons we learned from empirical research may be of value to policymakers in Mexico as well. I will start by saying that privacy notices or transparency in the realm of privacy are crucial, but I see them as necessary, not sufficient condition for privacy management. As a matter of fact, even as of 2021, we still see initiatives in the United States as well as in Europe, such as the GDPR, that although they attempt to improve consumer protection as it pertains to privacy, they still go back to a model essentially of notice and consent, providing information to consumers about what happens to their data and providing consent mechanisms, which in principle are all good things. We want users to know what happens to their data. We want them to have control over their data, but they can backfire in a number of ways when they are not, and if they are not coupled with basic safeguards, baseline safeguards of personal data. One way in which these approaches fail is by burdening consumers with so-called responsabilization, which is a terrible term for a terrible, to describe a terrible thing. Essentially, it's the expectation that consumers can and must take charge of problems they didn't really create and they cannot fully control. The term consumer responsabilization didn't start in the field of privacy, it started in the field of public policy and first in European circles. One area of application, for instance, is climate change, pushing the problem of climate change on consumers, asking them to change the way they eat, they drive, they wear clothing, in the hope or the belief that micro changes at the individual level can really rebalance the problem that mankind as a whole has with climate change. In the case of privacy, we have similarly a tendency to use consent mechanisms and privacy notices as a form of consumer responsabilization, pushing on consumers the burden of trying to resolve hurdles, which in fact are systemic and, in my personal view, cannot be resolved just at the individual level. They require societal, systemic solutions, which combine technology, computer science, and public policy. Um, the particular and unique hurdle that we face nowadays is what I call a evolutionary mismatch, and it may appear bizarre to talk about evolution at the privacy conference, but essentially the argument is the following. While some have claimed that privacy is a modern invention, a modern anomaly, research from a variety of disciplines, history, anthropology, ethnography, has confirmed that the drive for privacy protection actually spans time and geography across people of different social class, different degree of sociological and technological sophistication. You find evidence of privacy from the Chinese thinkers in the 3rd century before Christ, in ancient Rome, in the Meinaku tribe in Southern America, in Java and Bali before industrialization. Essentially, we have explicit evidence of privacy mores even in the ancient holy books of monotheistic religions, the Quran, the Talmud, the Bible. They all have references to what in modern language we would call privacy. Now, certainly, norms, opportunities, definitions, behaviors, attitudes or privacy do fluctuate over time and across cultures. Privacy-seeking behaviors do emerge across geography and in history. In fact, Irwin Altman, one of my favorite scholars in the field of privacy, famously wrote, "The drive for privacy appears to be simultaneously culturally specific and culturally universal." And the reason for that, which again may sound surprising to other audiences, but in fact, this is a concept that privacy scholars of the last century pushed and provided evidence for. So the reason for this universality and specificity is that there may be evolutionary roots for privacy needs and privacy drives. This idea can be found in Alan Westein's work, in Irwin Altman's work, in Ira Rubinstein's work. Essentially, under this evolutionary account, what we refer today as modern privacy evolved from a physical need for security, self-interest, self-protection, which over time evolved into more sophisticated human cognition. But here is the problem, and why this discussion, which may seem purely academic, is relevant to the hurdles we face today and that you are discussing at the conference. If people do rely in part on sensorial and visual cues to navigate privacy choices, the more we transition from physical to digital interactions, the less equipped we are for informed privacy digital decisions. So privacy responses, which are common in the physical world, may be muted online. And this explains why we face unique hurdles in protecting our privacy online, whereas offline, privacy behaviors are instinctual, almost automatic. We lower our voice when we have an intimate conversation, a dinner with our partner, if we see a waiter or some stranger approaching. We cover a private document when we are reading it. If we notice someone else close to us trying to read the same document. But online, we lack these cues. We do not literally see Google leaning over our shoulders, tracking our sensitive searches. We do not hear the NSA, National Security Agency, stepping closer, following us, listening to our video conferences, etc. And human beings may be wired precisely to rely on those sensorial cues to assess the privacy implications of their behavior. So essentially, this creates what in psychological literature an evolutionary mismatch. We have a drive for privacy, but online we are not essentially psychologically equipped to react to the stimuli, because the stimuli that we have evolved to rely upon for privacy decisions are lacking online. So what does this mean, to conclude, in the context of policy approaches to privacy management, which rely mostly on notice and consent, on making people read the privacy policies and giving them complex privacy settings. Essentially, this means that we cannot rely only on those mechanisms because much of our privacy decision making is visceral. Only to a certain extent, it is based on reading information about what will happen with our data, and that means that if a regulatory intervention only focuses on notice and consent, privacy policies, and choice mechanism, in our view, that intervention is destined to fail unless it combines the reliance on the notice and consent with other, as I mentioned earlier, baseline protections, with baseline safeguards of data, principles which have been well established in the literature, from data minimization to purpose specification, as well as if we, in my personal view, if we encourage the innovation and development of privacy-enhancing technologies, which increasingly could give us the tools to protect personal data while also allowing analytics to continue and society benefit from the collection analysis of the identified information. So in essence, my lesson here is that based on empirical research, we believe that notice and consent mechanisms, when disjointed from other baseline protections, cannot work well. And I hope that this lesson is something that can be shared with policymakers in not just in the United States, but or in Europe, but in Mexico as well. Thank you for inviting me to this conference.
Muchas gracias. Gracias, Alessandro. Bien, agradecemos mucho su valiosa participación. Ahora, permítanme presentarles a Andrés Barreto. Él es presidente de la Red Iberoamericana de Protección de Datos y superintendente de Industria y Comercio de Colombia desde septiembre de 2018. Es autoridad nacional con competencia en protección de las y los consumidores, datos personales,
personal data, and intellectual property. He is a lawyer by the University of El Rosario with a specialty on administrative law from the Pontifical University, and he holds a master in international affairs by the Externado University of Colombia and the Science Pool of Paris. He also holds a master on international legal affairs by the University of Barcelona. In the private sector, he has been the legal manager of engineering and services companies and entertaining companies as well. And he has been a lawyer for the Chamber of Commerce of Bogota. He was also a delegate in the capital of Colombia, and he was an advisor to the Senate of Colombia, and he was a lawyer and counsel for the president's office, and he was also managing the international relations for Bogota, and he was also a legal advisor in the Ministry of Foreign Affairs. He is member of the International Academy of the Colombian Academy of International Law and of the Bar of Colombia, and he's currently the Secretary General. Andres, thank you very much for joining us today. The floor is yours.
Comisionada, muchas gracias a usted.
Many thank you, Commissioner, for the invitation, and it is my honor to be here with you today, not only as a national superintendent for industry and trade of the Republic of Colombia, but also as the authority in charge of data protection. I believe that these conferences in a matter of data privacy are necessary given the evolution of this right and the different views that we have in different under different legal regimes, but the authorities need to work for this right. In some of the states, due to our constitution, it is a constitutional right, and in other states, we are they are trying to find how to protect the rights to privacy and protection. We see how different authorities evolve, and I am very glad to see the international consensus that we have been able to build. There are documents and statements that we have been working regarding flexible law. There are other documents regarding penalties. And one important thing that we have found is international cooperation, whether multinational or bilateral, with whom we share a legal regime. Multilateral cooperation has come through the Ibero-American Network for Data Protection, the OECD, and we have been able to find some convergence regarding other transactional issues like consumer protection and free competition, which is a topic that has been widely discussed by our colleagues at the OECD. We are very fortunate that in Colombia, the Consumer Protection Authority, the Data Protection Authority, and the Trade Protection or the Competition Authority lies within the National Superintendency for Industry and Trade, because we have a very overarching view of the issue. However, in Latin America, we face other challenges. We are still discussing the issues of privacy and protection. We are also discussing the digital economy in the light of our economy. And of course, we have these dilemmas where our states have foreign trade undertakings and commitments, and we have agreed to exchange information in order to monetize the data and to work and to be able to make profits. So it is very important that the authorities are aware that the decisions that they make will affect the lives of their citizens. And this is why we may have different opinions compared to the to common law, and and we also have different views depending on the country that we come from. We have much to do. Latin America is awakening to unicorns and to having our own platforms, and that will mandate us to check how large companies are behaving, because large companies are also looking for ways to find these small companies or third country companies to try to avoid paying taxes, etc. So I think that we should pay attention to that. We see how data privacy and protection have been very challenging, and we find different vehicles like influencers and how poor populations have become a very important market for technologies and for platforms and for content creators, and of course the social media. And while social media allow us to be interconnected and close some gaps and also overcome the borders, they also pose significant threats. That's what is happening with the FTC in the United States and the orders imposed by other authorities. Some companies were treated before as transnationals, but they behave differently in the market now. Before, we used to respect their jurisdiction, but now the data protection rules have changed and there are no physical borders. That implies bigger challenges for us. So while we do not have yet permanent coordination bodies, we have found points of convergence with other countries and with other authorities. In Colombia, we have been able to learn from other authorities, but we have also contributed to the global challenges like alphabet and YouTube and the use of social media by minors and a strong protection that our legislation provides to minors. So we will continue to work through the Ibero-American Network of Data Protection and with other authorities as well. We have all agreed that the purpose is to protect our rights. So I think that the discussions have been exceeded by the realities of the markets. And so data protection is the protection of a fundamental right, and in the digital era, we have to guarantee the rights of consumers who are using platforms to have access to goods and services. And we cannot just get stalled in the discussion about jurisdiction, but we need to protect those rights. And we need to also seek compliance. We need our citizens to be better informed. We need our students, our users, to understand that their data can be used to gain profits and that they can be used without their consent. So they need to be educated that they do not have to just click through everything. We need to develop a good and sound data policy for all business affairs. We think that our consumers must be protected from dangerous products as well, and that also involves personal data. And then fair competition authorities are also facing dilemmas because we have all these technology breakthroughs, and then we need to figure out tax rates against those technology breakthroughs. There is a lot of strain between platforms coming from the United States and the practices from the OECD and the reality of Latin America. So I would like to share this holistic, overarching view that I have from my position as an authority that comprises all three aspects. Now I am in charge of the temporary chairmanship of the Ibero-American Network for Data Protection, and we have worked on a document on penalties, and we will be willing to contribute that experience to you. Thank you very much. Well, thank you very much for your very clear presentation. And now we would like to ask Isabel Davara. Our speaker is the secretary of the Internet MX Association. She holds a PhD in law and is a bachelor on economic and business sciences by the University of Madrid. She is a lawyer in both Mexico and Spain, and she founded Davara Abogados, a legal firm specializing in the law of information technologies and communications. He is a professional that has been certified in privacy protection and project management in United States and Europe, and she is a member of the Association of Privacy Professionals. So she is a professor and a coordinator of a graduate course at ITAM, and she has been also a guest speaker in different institutions. She has been and national and international panelists in over 300 specialized discussions on the law of technology and communications. He is the author or the co-author of more than 150 articles and 15 books. Isabel, it is always a luxury to have you in a panel. Thank you very much. The floor is yours. Well, thank you, dear Commissioner. It is my honor to join you today, and I am very glad for this invitation. Thank you very much for this organization, and I would like to thank the other commissioners, particularly Commissioner Blanca Lilia Guevara. And again, I would like to thank Renato Mendoza and his team for this opportunity as well. I am here um, I am here to represent the Mexican Association of Internet, and it represents all the agents in the ecosystem, from the most relevant ones, from small platforms to large platforms, and we can play a role in the ecosystem. The industry, and the ecosystem, we want to comply with the law. We want legal certainty. My fellow panelists, Professor Dr. Acquisty and Dr. Barreto, have spoken about this, and we are only speaking about the Americas. And this takes me to the second item, which is the rights of consumers, or the human right to protect personal rights. The superintendent said that there should be a holistic view of all three things. But in Mexico, a consumer right is not a human right, but data protection is a human right. And but anyway, I would like to commend you on the name of a conference, because you have made it human-centric. And as we said that we needed legal certainty, and the more we can get rid of this disparity in our region, we will always be falling behind. It is not only about information and consent. It is a topic that is much broader than that. And my second item has to do that with the fact that whenever we speak about personal data protection, is much more technologically neutral, that we do not need to talk about what we understand as privacy or not, but we rather just speak about the treatment of personal data, and that could imply privacy, or the right to dignity, the right to honor, the right to forget. So this is a key right for other rights. And the ecosystem needs to be the top priority for this. And I am very sorry. It is very hard to follow the speaker. The sound quality is very, very bad. So at the interpreting booth, we are doing what we can. I am very sorry for that. And in the region, we are in a process where we are still developing. And when I mean the region, is not only Latin America, but the whole American continent, the Americas, we are lagging behind the standards and regulations from other parts of the world. And while it is true that some of our laws are really good, and even if it sounds bad to that self-praise is not good, the Mexican laws are really good, and we can speak about Article 52 of the regulation of cloud computing. This is an article that is now applied in Mexico, and the GPDR has made more progress on other items. But what I mean by this is that we need to to be aware of where we are standing in the region, and not only in terms of the regulations, but also in terms of our authorities and their strengths and their weaknesses. Because regardless of how strong or advanced our regulations are, like Brazil's, we need to have strong authorities as well. And then INAI could be considered the regional leader. In Mexico, data protection is a human right and not a consumer right, and this is why it has a broader application. It is also important that not to also highlight that not all the funds have been allocated to data protection alone, but all have also been allocated to the other function of INAI, which is transparency. So I think that we need to add something about proactive accountability. In the accountability system is close to you, to regulators, and to the academia, but we need a safe environment with sandboxes and where we can approach regulators and tell them what we want to do and learn from you so that we are all walking the same pathway. Thank you again, and it is my honor to share the panel with you. Thank you very much. Well, thank you, dear Isabel, for your very valuable contribution. And now we will continue with our speakers. I would like to introduce Jennifer Urban. Jennifer Urban is a professor of law of Berkeley School of Law, and she is the director of um, technology policy and innovation policy in Samuelson. Her research focuses on intellectual property, data protection, and security, and she works with people in the technology industry and in the law to develop new insights into how technologies and innovation and creative expressions are interlinked with each other. Her more recent projects are revolving around right to privacy, copyright, and freedom of expression, as well as open or source code and the smart grid, biometrics, and patents. She is the founder of the Intellectual Property Law and Technology Clinic of the University of South California School of Law. She was the first fellow of the Samuelson Clinic, and she is a lawyer by Venture Law Group in Silicon Valley. She graduated from Cornell University as with a degree in biology and neurobiological sciences with a PhD in intellectual property from Berkeley University. She was the director of technology while she was a student in Berkeley, and now we would like to give the floor to you, Jennifer, please.
Muchas gracias, señor. Buenas tardes desde California, en los Estados Unidos, and muchas gracias por incluirme. I am a professor at Berkeley, as the program says, but today I'm here because Governor Gavin Newsom in March appointed me chairperson of the board for the new California Privacy Protection Agency. The agency was created last November via ballot proposition, which means that it was passed by the people of the state directly, called the California Privacy Rights Act, which amended the California Consumer Privacy Act of 2018. I need to be clear that I am not speaking for the board or the agency, a university, but individually. Because we are so new, I thought it might be helpful to introduce the agency a little bit to this community. I am incredibly excited to be a part of the conversation. The California Privacy Protection Agency is the first of its kind in the United States. It's the first agency with full administrative power, authority, and jurisdiction focused on privacy here in the United States. So it is a very new endeavor, and I'm excited to join a conversation which is rich with decades of experience developed by authorities in other regions. As Commissioner Denham noted earlier in the day, California's approach stands firmly on the shoulders of previously existing laws, and I'm delighted to be here. I thought it would be helpful to say a little bit about the California approach for anyone who isn't familiar. First, the agency's implementing laws sets out clearly its underlying purpose. The agency is charged with protecting the fundamental privacy rights of natural persons with regard to the use of their personal information. And further, the agency is to seek balance the goals of strengthening consumer privacy while giving attention to the impact on businesses. Within that broad mandate and purpose, the agency has a number of responsibilities. Those include regulatory rulemaking, auditing, and enforcement, as well as public awareness and providing guidance to both businesses and consumers. In addition, we have other responsibilities, such as advising the legislature and monitoring developments in business and technology. I want to especially highlight one of our responsibilities and authorities, which is to coordinate with other agencies with jurisdiction over privacy and data protection. And that includes authorities in California, other states in the United States, and other countries to ensure the consistent application of privacy protections. I believe, as has been a theme throughout the day, that this is an incredibly important aspect of the agency's responsibility and authority. Commissioner Denham spoke of convergence. Many speakers today have mentioned the need for cooperation and an understanding of how all of our approaches fit together. And so I look forward to further discussion of that and of learning from everyone here today. Thank you.
Muchas gracias, Jennifer.
Thank you very much, Jennifer Urban. We thank you for your kind participation. Moving on to our next panelist, I would like to introduce Jules Polonetsky. He is Chief Executive Officer at the Future of Privacy Forum. He is a member of the Advisory Council on Security and Privacy at the School of Law of George Washington University. He is currently a member of the advisory boards of OpenBP, the Project for Privacy Tools at Harvard University, and the Privacy Lab of California. He is also the chair of International Council of Digital Responsibility, and he is a co-chair of the Institute for Technology Policy in Israel. Jules is a co-editor of the Consumer Privacy Manual published by Cambridge University. He was the privacy director and a special advisor to DoubleClick, which at that time was the largest internet company in New York. Since January the 1st, 1998, until he joined DoubleClick in March 2000, Jules was the head of the Agency for Consumer Affairs in New York City. He was also a lawyer at Struth and Lavin between 1989 and 1990. He graduated from the School of Law of New York University, and he is a member of the Bar of Washington and New York. Jules, you have the floor. Thank you.
Thanks very much. And I realize, given that consumer protection and data protection are part of the theme, that it may be useful to have been a consumer protection regulator who works in data protection. I think that the challenge that we're seeing today globally is the fact that we are advancing consumer protection law, we're advancing data protection law, we're advancing competition. And although we have some degree of cooperation often between these regulators, these are laws that are linked. When we've got cooperation, when it is an enforcement matter, obviously that's essential. But in the development of the law, we still see a giant gap. And I'll maybe just point to one recent example in the news. The preliminary, I guess we can cite it, even though it was a leaked draft of the Irish Data Protection Commissioner about what is a contract and whether data protection, guidance about what can be contracted for versus using consent or using legitimate interest is the determination of the data protection commissioner, or is this fundamental consumer protection law? And this is a case that's also been referred separately through a different action from Austria to the European Court of Justice. And so such an essential, matter, I think, is obviously a heated debate because of the particular action. But I raise it to show that the development of data protection law and consumer protection law, when so much of consumer protection law is increasingly about data, about transactions that have data as a key piece. How do we have these ideas develop separately? We have dark patterns, for instance, appearing in data protection law around the world. And of course, this is the reaction to data protection concerns that perhaps notices aren't being provided in a way that is, obligatory, or consent isn't given in an appropriate way. But we also have decades of consumer protection law that give us some parameters of what is acceptable, what is unacceptable, what is a pattern that is going to be a deceptive activity. The trend certainly seems to be, and our chair of our new California Privacy Protection Agency is sort of the latest example, at least for those of us, in the US. We're still debating whether the FTC should have carved out a separate data protection, entity. I've argued that there's value in having these entities very closely linked together, because if we're going to develop this notion of perhaps what is a dark pattern, it clearly needs to be a fused concept, right? If we're looking to ensure that the user understands when they're making a choice, whether it's a payment that is going to be applied, or whether it is a data that is now being exchanged. If we're talking about the same underlying issue, can these ideas converge? How will these agencies work together? So perhaps we'll see that in California, given one agency was built out of the other and will work in a close way, we'll see tight coordination. But I fear that we aren't always seeing that same mutual development of the law when regulators coordinate versus when law is developed and statutes that are in parallel developed. So I'll come back to that. I just couldn't resist with a brief comment. 2011, I think maybe some here in this panel and some in the room had the great pleasure of being in Mexico for the International Conference of Commissioners, the GPA predecessor. And I will tell you, it was still today one of the most magnificent data protection conferences ever, both because of the hospitality of our hosts in Mexico, as well as quite the quality of the speakers and the program and the panel. But the reason I raise it is not just to give a little thank you, again, for that decade ago hospitality, but there were a couple of I think very important resolutions that were passed at that conference as well that I was looking back on. One of them was focused on data protection and natural disasters, and called out some of the key consequences and key balances that needed to be made. And I think for all of us dealing with the reaction to this disaster of COVID, I think we saw that in countries where there was a robust data protection law, it was a lot easier to evaluate and assess the decisions that had to be made around contact tracing, around access to data for research. There were parameters. There was a notion of necessity and proportionality, and when consent was needed and when it was not needed because it was needed, but yet you still needed a minimization, you still needed restrictions in place. I will say that in the US, not having a national data protection law was only one of the significant factors that I think contributed to a lot of the chaos, because when measures were rolled out, we had some audience that said, well, that's not allowed under HIPAA, under our Health Privacy Protection Act, which of course doesn't cover anything like that, only covers certain types of medical and health insurance related information. So we had a vast number of not just the general population, but of experts and TV commentators saying, you cannot be asked your vaccine status because of HIPAA, when our HIPAA law has zero to do with this, unless it is perhaps happening in a medical context, certainly not your employer or otherwise. When we rolled out digital contact tracing, the concern, well, what other ways will this data be used, was a giant impediment for trust. And in some countries where you had a robust data protection law, one could say, well, no, just because we're using this method because the data needs to be shared because it's necessary, we still have obligations of minimization and limits on secondary use and proportionality. So you don't need to worry that it will be sold or it will be used for advertising, because the law doesn't allow that. And we didn't have a legal argument here to make to assure the population that if they shared data, or if government or companies or employers collected and shared data in these new ways, that they could be guaranteed that abuses weren't occur. So it was a thoughtful warning back then when this resolution was passed by the Commissioners' Conference, but it also, I think, shows us today the importance of countries having comprehensive data protection laws, not only for the day-to-day commerce, but for the times when we don't anticipate and when we need a thought-through structure so that we can move quickly without a long policy debate, because we've thought these things through. The other two issues that were key resolutions at that conference in 2011 in Mexico, one was international coordination around enforcement, which was already raised earlier. And I urge our friends at the GPA to further build the infrastructure. It is always a wonderful experience when we come to this conference, and I know there are some degree of activities, in coordination during the year, but we still, I think, don't have a real structured, ongoing, sophisticated, permanent mechanism for the kind of international coordination, when indeed what has happened in these 10 years is commerce and apps and remote learning has truly become global. I think in 2011 we thought it was, and we all talked about the need for international, cooperation and international enforcement. But it seems like a joke back then to think that we really had global, commerce. We could communicate with each other and maybe ship some product, overseas, right? When today the integration for almost every consumer who downloads an app in the App Store that can be made anywhere in the world, and if it's a nice program, hundreds of millions of users around the world. But we also have to recognize that what do we expect of some app developer who may be a small business, maybe a student, maybe a teacher looking to create an app that will do a better job at remote education, and truly informing them that because personal information is captured, which is almost always the case, they truly do need to somehow examine the laws of every jurisdiction in the world. I'm laughing today when I see some of our stakeholders who are the chief privacy officers of 200 of the largest companies in the world, who are spending untold legal resources analyzing, because they're not experts on the civil liberties and government law enforcement access, which they now need to examine in every country in the world to figure out when and how they can transfer data from Europe to the US. And with the significant resources that these folks have, it is a giant task. And everyone smaller than these is wondering whether we are bonkers, whether we are nuts. I don't know how to translate, right? Whether we are in a very silly land where we are expecting a small business or an individual who is perhaps a large data controller. This is the challenge that we have created for ourselves. We have a world where the individual can be, because of access to a global environment, a very significant data controller. So the cooperation that we need in order to make compliance easy, not just for those consumers, but for the legitimate organizations that want to serve those consumers, I think is quite compelling. And I hope that the GPA and some of the other global vehicles can build on more than conference and more than the platform activities that occur to really be a great vehicle for coordination. And GPAN and OECD and all these are phenomenal, but I beg for more as someone who sits both with consumer advocates, privacy advocates, small businesses, and large businesses. Look, we're at a time where it is more exciting than ever for those who are optimistic about what can be done with tech and data. We see people seriously studying how to make advances in medicine due to genetic analysis. We see how remote learning, as faulty as it was, and as poor as it was, and inadequate as it was, what a critical lifesaver it was. If we were only 5 years earlier, we would have shut down, schools with hardly any education. And here, although we managed well in the most affluent societies and less well even in affluent societies where all kids weren't treated equal, and certainly with a bigger challenge in societies and schools that didn't have the ability to quickly roll out education technology. But now we actually want to know what worked, and we want to study it, and we want to examine who was left out. And was it poor children? Was it children only of one skin color? We want to understand whether COVID is affecting one community differently than the others. And clearly there's optimism that with access to that sort of data, and perhaps even broader data than has been captured before, right? Data about what happened in people's homes, data about their ages and their income and all the different things we want to know to perhaps be able to improve. But of course, we see all the risks and all the challenges and all this discrimination and all the areas for commerce. And so the challenge, I think, for the regulatory world today is to, frankly, make sure that we are both enabling and disabling, that we are enabling the data that is available for research. Talk to some of the leading researchers in the world today, and they will tell you the challenges they have in accessing data. They want to study platforms, and because of privacy, because of business issues, they can't access the data so that we can study how effective are the platforms or not at what they're doing.